Hello, future company wizards, like corporate lawyers one day. Wish you all the best. Welcome to SQE1 window. And today we are diving into the world of directors once again. Not the ones in Hollywood, but the ones running our companies. By the end of this, you shall know your executive directors from your shadow directors, which was left in our previous session. We will gradually build upon everything in chain. So, first off, role and types of directors we will try to understand. What does a director actually do? Well, they supervise the management of a company. Think of them as the captain of a ship, except the ship may be a startup or worse, a sinking enterprise. So we have few types of directors: executive, the hands-on folks actually running the business. Non-executive directors, more like the wise aunt who tells you what to do but does not actually wash the dishes. So sometimes annoying and sometimes very wise, leading company out of trouble. So we got de facto directors, those who act like directors without the title. You know, the ones who sneak into meetings and suddenly everyone agrees with them. Shadow directors, people whose instruction the board regularly follows, even if they are nowhere on the formal chart. Think of them as puppet masters, and they are running company behind curtains. Remember, private companies must have at least one director, public companies at least two, and at least one must be a natural person, not a robot yet. Maybe in future it will be. So next thing is appointment requirements of directors. So directors are appointed either in the Articles of Association. So at that point, directors just look into, and removal is also possible through it, though it might feel like trying to evict your noisy neighbor. So that's very tough. A director can be removed for a number of reasons. So you can remove them for a number of reasons, for example, bankruptcy, automatic removal, long-term incapacity, or simply resigning because they have had enough of Zoom calls and they want to take their days off, retire. Special notice is needed. Once you need to remove them, 28 days notice. Tricky business. And you will be asked for advice once you are solicitors. And the directors has right to be heard. But beware of the infamous Bushell versus Fate clause. It's written in their contract. Directors can block their own removal if they hold enough shares in the same company. Sneaky, but that's right, because they own certain interest in that company, so it is hard to remove them. You can't remove them, they can block it. Otherwise, you convince them, go away. So register of directors. Every company keeps a register of director. It's like a VIP guest list. Full name, address, date of birth, the lot. Like it's date of birth, or public access is available online through Companies House. Private companies can sometimes skip the physical register if they notify the registrar, but most keep it just to be safe. Appointment, removals, and update must be filed within 14 days. Imagine forgetting. Not very corporate of you, is it? So, what are powers of director, and the board meeting will try to cover next, like, directors' powers come from the articles, constitution of company. They can bind the company to contracts, make decision at board meetings, and exercise authority in day-to-day operations of a company. There are three flavors of authority: actual authority, what they are actually allowed to do; implied authority, the power you assume they have it, like, if you meet a director; apparent authority, what outsiders think they have or what they appear to show. So at that point, remember, if a director acts within apparent authority, company can be bound even if director oversteps. Third parties must be cautious, though Don't just take anyone's word at fact value, unlike the dodgy eBay seller, So at that point, so on eBay it will be different, but once you are dealing with a company and they don't have authority, step away. So what are the board meeting? The board meetings can be held in person or remotely. Director may call a meeting by notice, even WhatsApp message can be sufficient. Decisions are made by majority votes, with the chair often holding a casting vote. And yes, records of decision must be kept for 10 years. Imagine explaining that to the auditor in 2023 if you were a director in a company. So, duties of director, there we come. They need to act within their part. Don't use the company fund to buy yourself a yacht. Promote success of company. That's what they need to do. Take long view, consider employees, customers, and even environment, all of it. And they need to exercise independent judgment. Don't blindly follow Aunt Mabel's advice. No. In them, care, skill, and diligence is binding on them. Basically, don't be negligent once you are taking any decision. You must avoid conflict of interest, that you don't secretly run a rival company. And don't accept benefit from third parties. No freebies or backhanders, not at all. No free tickets. Declare interest in transaction. Honesty is the best policy. So at that point, if you don't, it can put you in personal. Yeah, you need to personally pay for it. Breach of these duties can lead to damages or derivative claim, but don't panic. Ratification by the company or relief by the court can sometimes save directors from consequences if they acted honestly, that they were doing everything in good faith for the company. So, loan, property, and remuneration. That's what is important. Directors cannot just lend themselves company money willy-nilly, just take it. Most loans or substantial property transactions require members' approval. Remuneration is usually decided by directors themselves, though longer service contracts need shareholder approval. Think of it like an honor system. You are trusted, but you still need oversight, unlike a teenager with the Wi-Fi password. So, disqualification. Directors can be personally liable in certain situations, giving personal guarantees, misapplying company funds, fraudulent or wrongful trading during winding up. Disqualification can occur under the Company Director Disqualification Act 1986 from 2 to 15 years, from misconduct, fraud, persistent default, and insolvency related mismanagement. So yes, it's serious business, but it also keeps us honest and the company house officer reasonably busy with that. So, our favorite tips and pitfall. With tips, always distinguish between de facto, shadow, and formally appointed directors. They often pop up in question. What for conflict of interest and duties that we talked about in previous slides, previous session 171 to 177 of Companies Act 2006. Don't forget the special notice requirement for removal, 28 days, and the Bushel versus Faith clause, classic trap. Remember statutory authority under section 39 and 41? It's all about good faith and binding the company. And if you ever think about guessing, remember in company law, the devil is always in the details and sometimes in slightly overlooked cup of tea. So, from appointment to disqualification and everything in between, if you enjoyed this, give us a like, subscribe, and share. Thank you. Cheers.